It's common knowledge that the FDA is in collusion with the pharmaceutical industry. There's a revolving door between people who work for the FDA and people who work for the pharmaceutical industry that makes conflicts of interest a real issue for we the public. Now, there was an issue that came up that was just passed by the U.S. Supreme Court that protects pharmaceutical companies who are making generic products from lawsuits that might result from side effects from the drug that are not listed on the label. Now, we all know that all the side effects that the drug company knows should be listed on the label. And sometimes, or most of the time, they are. But there are times when they have certainly done things that are unethical, particularly the story that comes up of Vioxx, where we knew that for this anti-inflammatory drug like Advil and Aleve and Motrin and Celebrex, that these drugs caused heart attacks and strokes, and they withheld that from the FDA, as we've shown from Freedom of Information data that we've collected. So it's the law that if they withhold information or if there are side effects that develop during the time of treatment, so long as the patent hasn't expired, these drug companies are liable for what's not on the label that happens to people who have terrible side effects. But in the case of generic drugs, because enough time has passed, there's somewhere in the vicinity of 15 years that the pharmaceutical company has the patent rights to make the drug, most of the side effects will come out. However, by passing this law, which passed the U.S. Supreme Court only 5-4, so it was obviously a lot of controversy about what should have been done, it will give the generic companies very little incentive to find new side effects. I mean, why would you if you're already protected from it? And if you know of a new side effect and you list it, you realize that some people are not going to want to take that drug because it may cause a problem for them, particularly if they're prone to it. So here we have another case where there is some validity to wanting to protect a generic company because if they weren't protected, they'd have to raise the price, and they would be, again, at the level that the companies that have the patents on would be able to charge. But very often those prices drop 4 or 5 times less than what's been charged by a pharmaceutical company that holds a patent. But from the other point of view, it's one more example where we see the FDA colluding with the pharmaceutical industry to try and protect against drugs. The problem is we have a financial issue where return on investment is what the pharmaceutical industry is trying to protect. That's what its bottom line is. So we, the people, have to be more careful about how we use drugs. We should be more careful about listening to those direct-to-consumer ads that show real good things that are happening from their drug, but then the last 80% of the declaration is showing all the side effects that are possible to develop from the drug that's being used. So we should go back to lifestyle as much as we can and keep as healthy as we can by eating right and making sure we get enough sleep and exercise and our stress is low and that we're not exposed to any unnecessary environmental toxins, which includes drugs, because if we don't follow those lifestyle measures, we tend to become inflamed, and that is, of course, the final common pathway of this epidemic of chronic diseases that we're seeing. So keep in mind that the drug companies are protected, and they make a lot of money, and their bottom line is return on investment. It's not your welfare. If they can find something that will help your welfare, they'll certainly include that because that'll sell more drug. But if it doesn't, they may either conceal it, as they've done many times in the past, or they simply will try to do what they can to protect themselves through the FDA or now even the U.S. Supreme Court.